Welcome to Part 3 of the 5-part Patriot Corps presentation on Understanding Federal Tyranny. While the first two presentations explain the general principles that underlie the continuing abuse of federal authority, this third presentation begins to prove true the general concept in a specific case, as we begin to follow the money. The current presentation examines the enumerated power of Congress to coin money and regulate its value. To learn the meaning of these terms as understood by the members of the Second Congress who enacted the first Coinage Act under the Constitution. Part 4 of the 5-part presentation will examine the clever upholding of paper currency as legal tender for the first time under the Constitution in 1871. Even though 3 previous Supreme Court rulings all denied that the Legal Tender Act of 1862 made paper currencies a tender in the cases before them. The final presentation of this series will examine President Franklin D. Roosevelt's 1933 gold confiscation, which effectively prohibited private gold ownership for 40 years and effectively took us domestically off the gold standard. The primary purpose of the presentation today is to show that the power of Congress to coin our lawful tender money refers only to the striking of gold and silver coins of defined purity and weight and giving the coins proportional monetary values. Knowing where we've been helps us understand the devious process which got us to where we are today, left with only legal tender paper currencies. After all, no ratified amendment has changed any of the monetary powers of Congress. When discussing the powers of Congress, it is appropriate to start with the U.S. Constitution, the supreme law of the land. Article 1, Section 8, Clause 5 reads, Congress shall have power to coin money, regulate the value thereof, and a foreign coin, and fix the standard of weights and measures. The first thing to notice is that the power to coin money is that it is located within the same clause of the Constitution that empowers Congress to fix the standards of weights and measures. This is important because our money is meant to be our objective standard for value. While the purchasing power of money varies over time and circumstance due to the arbitrary decisions of countless numbers of consumers and suppliers, the dollar was intended to transcend discretion and long remain a fixed standard of 371.25 grains of pure silver. Just as an ounce and pound are known, identifiable and objective units established in the measure of mass, just as an inch and foot are objective units established in the measure of distance, just as the quart and gallon are objective units established in the measure of liquid volume, and just as the minute and hour are objective units established in the measure of time, so too are our units of the dollar, dime, cent, and mill, objective monetary units of account established for the measure of value. In other words, while the dollar's purchasing power would vary, its definition of a defined amount of pure silver was meant to be indefinitely fixed. Indeed, that is the explicit purpose for fixing an unvarying standard, to establish known and knowable benchmarks, and in this instance, measuring value. The best means to learn the meaning of various clauses of the United States Constitution is by examining early legislative acts enacted during a period of time when the members of Congress took seriously their constitutionally delegated roles, and no controversy developed immediately afterwards that challenged the actions implemented. Today's presentation will examine the power of Congress to coin money by examining the first monetary act under the U.S. Constitution, the Act of April 2nd, 1792. Section 13 is a good place to begin because it ultimately shows just how serious were those members of Congress to provide the Union with honest and objective money. Section 13 of the 1792 Act specifies the purity standards for silver coins, detailing, quote, that the standard for all silver coins in the United States shall be 1,485 parts fine to 179 parts alloy, and accordingly that 1,485 parts in the 1,664 parts of the entire weight of each of the said coins shall consist of pure silver, and the remaining 179 parts of alloy wholly copper. Unquote. Patriots unfamiliar with the term fine, as used in the first part of the section, can see in the second part that it refers to purity of precious metals. In the present case, it refers to the amount of pure silver in the silver coins that are ultimately struck with an alloy to toughen the coin against abrasive wear for better durability. In Section 12, The word fine is also used to describe the pure gold in the gold coins. Silver and especially gold are soft, but adding an alloy increases the coin's resistance to abrasion. Large silver coins, alloyed with copper, habitually lose about 1% of their weight in 50 years of circulation. Large gold coins, 2%. Smaller coins, with greater surface area relative to their total weight and which often saw greater circulation, typically suffered greater abrasive wear. Under Section 13, one notices the odd purity standard of 1,485 parts of pure silver to 179 parts copper, for 1,664 total parts of silver and copper combined. Compare that particular silver standard with the simple standard specified for gold, found in Section 12 of the 1792 Act, which read, quote, that the standard for gold coins of the United States shall be 11 parts fine to 1 part alloy, and accordingly that 11 parts in 12 of the entire weight of each of the said coins shall consist of pure gold, unquote. While the standard for silver coins in 1792 was 1,485 of 16/64ths fine, the standard for gold was 11/12ths fine. It should be noted that the 11/12ths fine is the same mathematically as 22/24ths fine, which is important because gold is often discussed in terms of carats, which examines the purity of gold in 1/24th parts. Thus, 22/24ths fine is equivalent to 22 karat gold, 24 karat gold being pure gold. 14 karat is nearly 60% gold, with 18 karat gold being 75% gold. Examining the percentile purity of coins under the 1792 standard, one sees that under this early standard that silver coins were 89.243% pure, gold 91.67% pure. The purity of gold is often discussed in parts per thousand, so the gold purity in thousandths in this case would be 916.7 fine, often rounded up to 917 fineness. It should strike listeners as rather odd that while the standard for purity of gold was the simple 11/12ths fine, silver was 1,485 of 16/64ths fine. Indeed, the assayer at the mint complained bitterly about this cumbersome silver standard, especially given how rudimentary technical processes were at the time. But it was his job to meet the exacting standard set by Congress. In fact, he would be disqualified from office under Section 18 of the Act if annual assays for each separate mass of silver failed to come within 143 of 144th, or 99.3% of that targeted purity. Section 11 of the 1792 Act, the last of the sections which touch upon the topic of purity, sets the stage for understanding the odd silver standard detail in Section 13, reading, quote, that the proportional value of gold to silver in all coins which shall be by law be current as money shall be as 15 to 1, according to quantity and weight of pure gold or pure silver, unquote. The proportional value of pure gold to pure silver shall be 15 to 1 in all coins current as money. Money being current acknowledges that money can also become no longer current or obsolete. We'll touch on that topic shortly. It is important to delve into that precise but peculiar purity standard for silver coins. But to do that, it is helpful to cover first the coinage standards for weight. Section 9 of the 1792 Coinage Act specifically lists the precise coinage weight of given coins of particular precious metals at given dollar values. The dollar was defined in Section 9 as a coin of 371.25 grains of pure silver, weighing 416 grains total, the latter number including the weight of the incorporated copper alloy. For those people unfamiliar with the grain, it is the smallest unit typically used for measuring mass, herein casually referred to as weight, originally equal to a plump grain of barley. In the troy weight classification that is used for weighing precious metals, 24 grains are found in a pennyweight, and there are 20 pennyweights in a troy ounce. Therefore, there are 480 grains in a troy ounce, with 12 troy ounces to the troy pound. With 360 grains equaling 3/4 of a troy ounce, one silver dollar of 371.25 grains had a little more than 3/4 of a troy ounce of pure silver in a coin weighing nearly 7/8 of a troy ounce, counting its copper alloy. Section 9 of the 1792 Act also specified the half-dollar as a coin with exactly one-half the number of grains of pure silver as the silver dollar, the quarter dollar as a coin with exactly one-fourth the number of grains, the dime as a coin with exactly one-tenth the number of grains, and the half-dime as a coin with exactly 1/20th of the number of grains of pure silver as the silver dollar. Of course, all these subsidiary coins would actually be struck in standard silver at the purity standard of 1485 of 1664ths fine. Section 9 likewise specified the eagle as the coin of 247.5 grains of pure gold, weighing a total of 270 grains total with alloy and valued at $10. Here, one sees that the United States, strictly speaking, were established on the silver coin standard along with the gold coin equivalency, essentially establishing a bimetallic monetary system. It was not that the eagle was $10, but the eagle was the unit coin of gold valued at $10. Coins of gold were defined in terms of eagles, but given an equivalent dollar so we could have a single monetary accounting system based in dollars available in two metals to reach purchases high and low. Copper cents and half cents were also struck, and while they had a stated value, they were not lawful tender. This distinction of the silver coin standard along with the gold equivalency is important because the 15-to-1 proportional relationship established by law in 1792 would invariably need to be regulated or changed at some future point in time, such as it was in 1834. After all, no government can forever fix two differing metals at fixed ratios without eventually losing the metal undervalued domestically to foreign jurisdictions which properly value the metal according to its worldwide values. Either the legal ratios must change with changes in the world value, or the undervalued metal will soon be depleted domestically. Besides the $10 gold eagle, also established in 1792, were the half eagle of 123.75 grains of pure gold and valued at $5, and the quarter eagle of 61.875 grains of pure gold and valued at $2.50. All coins of gold were precisely valued according to their strictly proportional weight of pure gold, just as all coins of silver were valued strictly according to their weight of pure silver. To summarize, although the legal value of coins was determined only according to the weight of pure gold and pure silver, pure gold or silver coins weren't struck because pure gold or pure silver coins would wear too quickly. Coins of both metals were first toughened with alloy to resist abrasion better. The alloy added no value to the coins, including even the silver alloyed with copper for alloying gold. Sections 13 and 12 of the 1792 Act discussed the purity standards of the silver and gold coins. Section 11 discussed the relative value between gold and silver purity, and Section 9 discussed the standards for weight. Having covered the necessary background information, it is now time to delve into the odd purity standard for the silver coins to show how members of Congress established honest and mathematically consistent money. Recall from Section 9 that Congress established the dollar coin of silver to contain precisely 371.25 grains of pure silver in a coin, weighing with its copper alloy 416 grains. Also, recall from the same section that the eagle was established as a coin of gold valued at $10, weighing 247.5 grains of pure gold, and a coin weighing with alloy 270 grains. To compare a coin of silver and gold, it is appropriate to look at the same dollar value. Since the unit coin of silver was the dollar coin and the unit coin of gold, the eagle, was a coin worth $10, one may either examine an eagle's worth of silver, 10 silver dollars, or a dollar's worth of gold, 1/10 of an eagle. For the sake of simplicity, we'll compare a dollar's worth of gold with a dollar's worth of silver. Since there are $10 worth of gold in one eagle, it is necessary to divide the eagle by 10 to come up with the equivalent of 24.75 grains of pure gold in $1 worth of gold. Since Section 11 of the 1792 Act specifically made an equivalent weight of pure gold worth 15 times the corresponding weight of pure silver, a dollar's worth of pure silver would have to be 15 times the weight of a corresponding value of pure gold. Taking a dollar's worth of gold, 24.75 grains of pure gold, and multiplying it by 15 as Section 11 demands, equates to 371.25, which is the precise amount of pure silver specified in one silver dollar in Section 9. Thus, one sees mathematically that Sections 9, 11, 12, and 13 are all starting to align properly, as one would expect. Carrying the math forward proves that all the sections of the 1792 Act align fully. Again, recall that Section 9 specifies $1 to contain 371.25 grains of pure silver in a coin weighing, with copper alloy, 416 grains. Working with fractions or decimal equivalents are more difficult than working in whole numbers. Changing the numerator in the fraction 371.25 of 416 to a whole number helps simplify the math. Since the numerator of 371.25 grains points to 1/4 of a grain to the right of the decimal place, to get a whole number, it is necessary in this case to multiply that number by 4. Multiplying 371.25 by 4 equals 1,485. Since the numerator had been multiplied by 4, so too must the denominator. 416 multiplied by 4 equals 1,664. Subtracting the 1,485 from the 1,664 equals 179. One should recognize these precise numbers as the numbers specified in Section 13 of the 1792 Act for the purity standard for silver, being 1,485 parts silver to 179 parts copper, for 1,664 parts total. The purity and weight standards established by the 1792 Act demonstrate the objective measure of precious metals to correspond with the established units of monetary value. All sections of the 1792 Coinage Act are mathematically consistent with one another, down to precise levels that were at the time difficult to attain. Members of Congress provided Americans with money with an objectively regulated value according to their enumerated power to coin money and regulate its value. Members of Congress took very seriously their sworn duty to establish the true and consistent standard of value which is required of our constitutional money, coins that were struck in gold or silver at mathematically consistent weights and purity. Section 11, discussed earlier, pointedly declares that principle, stated here in its shortest truth, quote, that the value of all coins which shall by law be current as money shall be according to quantity in weight of pure gold or pure silver, unquote. Nothing was more plainly stated. The value of all coins current as money shall be according to quantity of weight of pure gold or pure silver, period. Of course, since pure silver and especially pure gold coins were too soft and would in that pure state degrade too quickly from abrasive wear, alloy was added to toughen the coins, but that alloy did not add to the value of the coins. The simple statement of Section 11 that, quote, the value of all coins which shall by law be current as money shall be according to quantity in weight of pure gold and pure silver, unquote, proves that a coin without gold or silver had no lawful tender monetary value for the states of the Union united under the Constitution. Nor has the Constitution ever been amended to change that express principle. Therefore, even today, a coin without gold or silver has no lawful tender monetary value for the states of the Union united under the Constitution. Instead, Americans have been falsely led to believe that coins without gold and silver are legal tender throughout the Union at values historically reserved for these precious metals, and especially that paper currencies irredeemable in gold or silver are a legal tender because they falsely think the Supreme Court ruled that way long ago. That false assumption will be the topic of our fourth presentation. In the meantime, the 1792 Coinage Act still has more to teach us about constitutional money. Section 16 of the 1792 Coinage Act similarly declares, quote, that all the gold and silver coins struck at the mint shall be a lawful tender in all payments whatsoever, those of full weight according to their respective values, and those of less than full weight at values proportional to their respective weights, unquote. The lawful tender value of all gold and silver coins shall be according to the weight of properly pure gold and silver coins. Again, another statement specifying lawful tender money to be gold and silver of proper purity and appropriate weight. While full weight coins were valued under the 1792 Act at their stated legal value, coins light of weight were valued only according to their proportional weight. If a silver dollar was struck at only 98% of intended overall weight of 416 grains with alloy, the lightweight coin would only be valued legally at 98 cents. The early coins were not struck with their value. It was presumed that the value of all coins would be determined at the time of purchase and sale by physically weighing the coins to determine their standard weight. Then, knowing their purity, the coin's legal value could be ascertained mathematically. It was not until 1837, when the art and science of striking coin had advanced sufficiently, that both gold and silver coins began to pass officially by tale. By the count of the coins, lightweight coins were therefore culled from the circulation and struck into full-weight coins, and precise standards for both weight and purity were set within allowable tolerances. While the 1792 Coinage Act set very strict measures for purity, because purity was so difficult to determine, especially after a coin was struck, their target weight didn't have established tolerances beyond the mint's official, quote, best endeavors to reach the targeted weight. Section 14 of the 1792 Act made it lawful for any person to bring to the said mint gold and silver bullion in order to be coined free of expense. The free coinage of money out of depositors' gold and silver bullion meant that the people depositing gold and silver bullion would have to wait for their coins to be struck out of the physical metal they had left at the mint. Once the mint got ahead of orders and was able financially to keep on hand a small store of coined money, the act allowed depositors to receive gold and silver coins immediately after their gold and silver bullion had been assayed to determine its value. However, in this latter case, the mint was allowed to charge 0.5% of pure bullion value for the depositor's convenience of receiving coin immediately. Section 19 of the Coinage Act of 1792 is the last of the sections to examine, and it shows just how deadly serious members of the Second Congress took their role to coin honest money. It reads, quote, that if any of the gold or silver coins which shall be struck at the said mint shall be debased or made worse as to the proportion of fine gold or fine silver, or shall be of less weight, through the connivance of any of the officers with a fraudulent intent, every such officer who shall commit the said offenses shall be deemed guilty of felony and shall suffer death. So serious did members of Congress commit to coining honest money, they prescribed the death penalty for any mint officer who intentionally sought to debase or clip the coins with fraudulent intent. What the mint has done daily since 1965, making coins without any silver but said to have legal value equivalent to the old silver coins, would have been punished by death in 1792. The bottom line is that the first Coinage Act under the U.S. Constitution properly laid out the absolute rule of lawful tender value being proportional to weight and purity of gold and silver in coins struck, according to fully consistent law. While we have completed our discussion of the 1792 Coinage Act, Article 1, Section 8, Clause 5 of the Constitution yet offers us more to study. Besides having the express power to coin and regulate the value of American money, members of Congress may also regulate the American value of foreign coins, simply by assaying the purity of foreign coins to come up with a comparable price based upon the weight of gold and silver relative to the American coinage standards. It is important to notice that Clause 5 discusses the coining and regulating of the value of American money, but only allows Congress the express power to regulate the value of foreign coins. By using money as the noun dealing with coining and regulating the value of American money, but using coin as the noun dealing with regulating the American value of foreign coin, it could appear to the uninformed that the Constitution has differing standards for American money and foreign coin. Indeed, proponents of paper currency point to this difference to say it proves their point that American money includes things beyond coin, i.e., that it extends to paper currencies. For additional support, proponents of paper currencies next point to Article 9 of the Articles of Confederation, the earlier form of government established for a short time before the Constitution was ratified, with its words, quote, "The United States in Congress assembled shall have the sole and exclusive right and power of regulating the alloy and value of coins struck by their own authority or by that of respective states," unquote. Thus, since the alloy and value of coin struck obviously points only to metallic coin, then surely the U.S. Constitution allows Congress greater discretion in the creation of money, so the argument goes. However, Both citations only cite the half of the founding documents that support their view, while ignoring the other half which decisively refutes it. Careful examination of both the Articles of Confederation and the U.S. Constitution shows that the latter is actually far more restrictive monetarily than were the Articles. As the Articles of Confederation show, the states retain the lawful authority to coin their own money, following any uniform standard Congress would set. However, neither Congress nor any state ever established any mint for striking gold or silver coins, as it simply was beyond their means and ability. The first sign that the argument espoused by paper currency advocates falls short of the truth is found by reading another portion of the Ninth Article of the Confederation, which reads, quote, "The United States and Congress assembled shall never coin money, nor regulate the value thereof, nor emit bills, nor borrow money, unless 9 states assent to the same," unquote. In this passage, one notes that the noun here being referenced is money, with coin again being the verb, just like Article 1, Section 8, Clause 5 of the U.S. Constitution. Therefore, the money being coined by this portion of the Ninth Article is the same coin being earlier struck. The argument for paper currency under the Constitution falls even further upon reading Article 1, Section 8, Clause 6 of that Constitution and its words that, quote, "The Congress shall have power to provide for the punishment of counterfeiting the securities and current coin of the United States," unquote. Here, one sees the money of Clause 5 that was there being coined is the same current coin that Congress may punish the counterfeiting thereof in Clause 6. Thus, the Articles of Confederation and the U.S. Constitution both use the terms coin and money interchangeably to mean one and the same thing, coined money of gold or silver. Thus, while the Ninth Article of Confederation discusses the alloy and value of coins struck, Article 1, Section 8, Clause 6 of the U.S. Constitution discusses the punishment of counterfeiting the current coin of the United States. Coin in both places is being used as the noun. And, while Article 1, Section 8, Clause 5 of the U.S. Constitution discussed the power of Congress to coin money, the Ninth Article of Confederation likewise discussed that the United States and Congress assembled shall never coin money unless 9 states assent to the same. In both of these latter instances, coin is the verb and money is the noun. However, even more informative about the extent of powers included within the phrases, notice the specific phrase of the Articles of Confederation that Congress shall not coin money nor emit bills unless 9 states assent to the same. Emitting bills refers to emitting bills of credit, i.e., paper currencies. With this enumerated power under the Articles, one understands that if 9 states assented to the emission of bills of credit, then Congress under the Articles of Confederation could print and issue paper currency. In other words, in a government of delegated powers, the words about striking coin and coining money did not reach to emitting bills of credit, because that explicit power had to be separately listed to be an allowed power. Therefore, with the power to emit bills expressly named in the Articles of Confederation, the delegates of the Confederate Congress could emit the bills as long as the qualification was met, i.e., as long as 9 states authorized it through their delegates in Congress. However, in a government of delegated powers under the U.S. Constitution, no similar delegation of authority to emit bills of credit was therein named, meaning that, under the Constitution, members of Congress may not emit bills of credit throughout the Union. Indeed, the express power to emit bills of credit was formally proposed at the Constitutional Convention on August 16, 1787. It was then fully discussed and then expressly voted out of the draft of the proposed Constitution by a vote of 9 states to 2. New Jersey and Maryland voted to keep the power in the proposed draft. The other 9 states present at the convention all voted to remove the offending words, while New York was absent from the convention after July 11th and no delegates from Rhode Island ever attended. One may read James Madison's words in the Federalist No. 44 about the pestilent effects of paper money and the unadvised measure of emitting bills of credit being voluntarily sacrificed at the convention on the altar of justice and thrown out as a proposed power of Congress. The U.S. Constitution also speaks to bills of credit in Article 1, Section 10, Clause 1, which reads, quote, "No state shall coin money, emit bills of credit, or make anything but gold and silver coin a tender in payment of debts." unquote. Here one sees that an express prohibition prevents the states of the Union from striking their own coin, but also from emitting bills of credit. With Article 1, Section 10 explicitly prohibiting the states from coining their own money and from emitting bills of credit, it is obvious that the founders of the U.S. Constitution did not consider the phrase "to coin money" to include a coordinated power to emit bills of credit. Indeed, if they had, then prohibiting the states from coining money would have been enough to also prohibit them from emitting bills of credit. Therefore, just like the Articles of Confederation, the words "to coin money" under the U.S. Constitution do not include the powers to emit bills of credit. One cannot consistently hold two different documents of the same era, written by largely the same group of men for the same jurisdiction, to two different standards, let alone hold the same document to two different standards. That the proponents of paper currency stoop so inconsistently low to support their views show how fragile is their advocacy. Under both established forms of government, the Articles of Confederation and the U.S. Constitution, the powers to coin money does not include the power to print a paper currency. Because the Articles expressly listed the power, Congress under the Articles could emit paper currency. Because the Constitution omits any such reference, the government of enumerated powers exercising only necessary and proper means cannot emit legal tender paper currency for the Union, as the Supreme Court correctly ruled 3 times. Yet, patriots today well know that the paper currency notes which circulate widely today declare themselves to be, quote, legal tender for all debts, public and private, unquote. Something odd is obviously occurring as actions, events, and circumstances abound that oppose founding principles. What that something is will be discussed further in the next presentation, Part 4 of Understanding Federal Tyranny. As is always the case, ever-elusive symptoms need a full and accurate diagnosis of the underlying real issue before the appropriate cure can ever hope to be properly provided. In summation, the important takeaway from Part 3 of this 5-part presentation on Understanding Federal Tyranny is that the 1792 Coinage Act specifically showed the firm rule that the value of all coins which shall be by law current as money shall be according to the quantity and weight of pure gold or pure silver. Nothing could be money without gold or silver. The next presentation will examine the odd transition from only gold and silver coin as lawful tender to paper currency also being declared a legal tender by the Act of February 25, 1862. The last of the 5 presentations will discuss the removal of gold from active circulation to leave domestically only irredeemable paper currency to teach patriots how their money was stolen from them. Patriots may then look again to parts 1 and 2 of this presentation to find the appropriate cure not only for the single symptom of Americans being deprived of their lawful money, but also for correcting all other symptoms by applying the appropriately diagnosed cure to the single political problem actually facing us, which is how members of Congress and the federal officials may ignore their constitutional constraints with impunity. For those persons wanting additional study materials and more in-depth background information, please see any of Matt Erickson's 9 public domain books found at the patriotcorps.org website. God bless these United States of America and the Republic they founded.